Good afternoon. This is Clarence again from Trosho Law Office PC. The subject matter for today's episode relates to employment authorization document or work permit based on asylum. But before I go there, let me revisit our last episode for certain clarifications. Number one, there's a laundry list of exceptions to the public charge rule. I probably omitted to mention specific exceptions like being an asylee, refugee, or a victim of trafficking or abuse or VAWA. And also as a SIJ, special immigrant juvenile, they're exempted from the public charge rule. That's number one. Number two, also all testing and treatment in relation to COVID-19 or during the pandemic is also exempted from the public rule charge. And lastly, I made a distinction between non-cash public benefits, which does not render or which did not render you inadmissible under the prior or previous rule. And during that rule also, during the time, only cash-based benefits would make you inadmissible. But under the new public charge rule, the distinction has been eliminated with few exceptions that I mentioned earlier. So moving forward, just be aware of that, and it's a clarification of what has been discussed previously. Now, back to today's episode. This is about work permit based on asylum. So there's a rule that will take effect August 25th, 2020. That would be Tuesday next week. Effective by then, the processing time for the work permit would not be mandatorily start within 30 days from the time of submission under the new policy implemented by the government, ostensibly to minimize fraud, to do some more background checks of the applications. Next is the waiting period for the work permit before you could actually file for it. Now, from the time of filing, for example, today you have to wait for 365 days before you could actually file for your work permit. Used to be before 150 days. Now you have to wait effectively for 1 year. Now, given the delay that I mentioned earlier in the previous episodes in the processing of the work permit, practically what will happen is an asylum applicant, for example, will probably get the actual work permit probably a year and a half from now, or even longer than that. So that's the practical side. People also who entered the country unlawfully, with few exceptions, are no longer entitled for a work permit. The exceptions generally are people who did such an entry, unlawful entry, not at the port of entry because of imminent threat or medical condition, or who have presented themselves within 48 hours to an officer, may still be eligible, but those are exceptions rather than the rule. Also, people who applied for asylum or who filed their application more than a year from the time of entry are also no longer entitled to a work permit until such time that there's a definite finding by a judge down the road, most likely during the final hearing, that he or she falls under the 1 year exception under the rule, in which case this will probably happen like more than a year at the very least from the time of filing. But by then, if you're granted, it's already more than academic because you're already entitled to another work permit as an asylee. Now, the other thing is, once you apply for your asylum, once you're denied by the asylum office or by the judge, unless there's an appeal, the work permit that you have could likewise be terminated. In addition to that, there's a series of disqualifications, one of them being convicted of an aggravated felony at any time during your stay in the United States, and even for some serious non-political convictions previously in your home country, regardless of whether it's related to your claim or not, could actually disqualify you for a work permit as well. Now, moving forward from August 25th onwards, if you are convicted of a felony, aggravated felony as I mentioned, and even for public safety violations like endangerment of a child or DWI, such convictions could actually disqualify you from work permit as well. Now, there are legal issues involved as to this. Number one, aggravated felony at any time. Does this amount to an ex post facto law, or is it in consonance with a disqualification under the law for a particularly serious crime for which an aggravated felony may be considered as such? But then again, there's a question of whether all aggravated felonies are necessarily particularly serious crime. Now, the bottom line is there are certain convictions that people would just enter to a plea simply to obviate any prolonged litigation. I don't know if criminal lawyers actually would now be required to advise the applicants regarding this particular disqualification as to a work permit related application, considering that this is still considered as an effect on their immigration benefit, and what will happen if they don't, right? Also, DWI used to be a misdemeanor before. Most people would just enter a plea considering or knowing that it will not affect them. But the more serious one is aggravated felony conviction at any time. Used to before that you have to understand aggravated felony is a very technical term. It varies in what context you are being considered as an aggravated felon, because aggravated felony may have a different definition technically under criminal law and under immigration law. And some people would opt for a plea agreement or compromise in a criminal court, knowing that it is lesser than the actual imposable or penalty to be imposed, but it may have a ramification for immigration purposes. The question then is, if the conviction, for example, DWI, driving while intoxicated or under influence, if such conviction does not disqualify you for asylum, why would it disqualify you for a benefit that is an adjunct or corollary to the principal application? So those are certain issues that have to be dealt with, but moving forward, as I said, you have to be very, very aware of that. Also, other things is, there's so many ramifications that you have to consider. So again, this is not a legal advice, just be aware of that. And if you fall under any of those disqualifications, it is highly advisable that you consult a lawyer and be very, very aware once you file such an application. Now, I have to add that I mentioned earlier about discretion, greater latitude, leeway for the immigration officer to deny applications based on that. Considering these new developments, then there's a question as to how these disqualifications could be construed by the immigration officer when the time comes. Those are nuances, as I said, that we have to deal with. Now, someone told me that there should not be a laundry list of 1, 2, 3 items that could disqualify you. But unfortunately, at the end of the day, I'm like a laundromat where people drop off their dirty laundry, and I have to account for those pieces of laundry and to the customer, so to speak, for them to be aware and to have a clearer picture of what's involved or what has been left behind or what could be left out. That's where we are. We're trying our best not to give you a laundry list, but hopefully you understand why we have to at some point. In fact, there's another laundry list that I almost forgot. They have this new circular that just came out yesterday, I believe, wherein considering the delay in the work permit processing, immigration came out with this guideline wherein people who have an approved or notice of approval of the work permit from August of last year to August 20 of this year may use such notice of action or approval for purposes of verifying their status in the country. In terms of I-9, that's a verification form that employers use to verify the status and eligibility to work in the United States. And considering that there's a delay as to the actual card being produced, as I mentioned earlier in the previous episodes, such notice of action of approval would suffice for that purpose. Not for identity, there's a distinction again, but you have to talk to your employer regarding this new guideline. And as I said, there's a time element to this. This guideline is only valid up to December of this year, December 1st actually. So you have to know when the work permit expires, when you have to deal with your employer, and whether the employer would have the proper advice, guideline, or policy regarding this new development. I hope everyone is safe. I think that's it for today. I'll keep this as short as possible. Please be safe. Unfortunately, a friend of mine just passed away this morning in London. So I guess, I think at some point we may have such sad stories around us. A lot of people are getting sick that I personally know, and I implore you to be safe. All right, thank you.